Okay, do we have Chair Cherry here on the line?
President Tollefson, I believe Chair Cherry had to step away this afternoon. He did send an email and asked me to fill in for him.
That's right.
I would like to, on his request, be able to do this today. I'm happy to do it now, but since we are not waiting, I'm okay if we want to finish conversations for fluidity of and consistency to go through that. Either way works for me. Up to you.
Well, my understanding is that this has to be carried out today and then has to be carried out again at the next board meeting in order to comply with some practice of law board rules and regulations.
That is correct.
Okay.
All right. Well, I'm going to do my impression now of Michael Cherry. So let's see how this goes. President Tollefson, President-elect Clark, past President Cicchetti, Director Nevitt, Board of Governors, staff members, and members of the public. At the Practice of Law Board's annual meeting with the Supreme Court, the board presented a summary of the board's recommendations for a legal regulatory lab. The board has promised to get final recommendations to the court by July 1st, 2022. Under GR 25, the Practice of Law Board must provide the Board of Governors with 90 days to comment on any proposal the Practice of Law Board makes for new legal services to the court. The Practice of Law Board has provided a copy of the blueprint which documents the board's recommendations to each governor, and the Practice of Law Board would be happy to answer questions about the blueprint that any governor or member of the public may have. A key goal of the Practice of Law Board is to send the best recommendation to the court. Therefore, the Practice of Law Board would appreciate any comments and feedback about the blueprint. The board will try to incorporate all feedback into the blueprint before it goes to the court. There are some misconceptions about the blueprint and about a legal regulatory lab, and the Practice of Law Board would like to address some of those. The first assumption is that a legal regulatory lab creates or endorses unregulated legal services. It doesn't. A legal regulatory lab is a process for data-driven regulatory reform. People, including lawyers, come to the lab with a proposal for modified regulation, which allows the provision of a new type of legal service, following a set of regulations customized to ensure the service does not harm the public and which measures the legal service's impact on access to justice. The process calls for ongoing monitoring of the legal service to craft the correct regulation to protect the public. A second assumption is that a legal regulatory lab creates competition for lawyers. The market for legal services in Washington and other states is large, and there are many different types of legal service providers. But even in a robust market, there can be gaps. Consumers can be looking for legal service, but they cannot find a service that suits their needs at a price they can afford. Markets with such gaps can be disrupted. For example, in the last several years, communities have seen disruption hit the market for regulated services such as taxis, shuttle services, and short-term accommodations such as hotels and motels. The legal services market will not be immune to such disruption, despite unauthorized or unlawful practice of law statutes. Whether participants in a market accept the concept of market disruption does not affect whether it is occurring. Instead of seeing disruption as creating competition, legal professionals should see it and the legal regulatory lab as an opportunity to offer new services to clients and as an opportunity to try new business structures for law firms and other means of providing legal services. In Utah, where data-driven legal regulatory reform has been underway in a sandbox for almost a year now, most participants are Utah lawyers. Washington lawyers should be embracing the opportunity to look at those regulations which may affect how they manage their business, such as rules on fee splitting, referrals, and who can have an equity stake in a law firm, and use the lab to show there is a better way to protect the public from the harm such rules were intended to prevent. Such changes could even benefit those legal professionals who have traditionally been most underrepresented in the current legal service market, because it allows these underrepresented communities to experiment with service models tailored to their community. The next assumption is that legal professional members must pay for the legal regulatory lab. From the onset, the blueprint calls for the legal regulatory lab to be self-funding. Most of the participants covering the costs of operating under the customized rules, and if approved for admission or license to practice using customized rules, that they are shown to work by license or transaction fees. The Practice of Law Board has proposed a new idea for WSBA, charging back for services where WSBA has the expertise in-house and such expertise is not available outside of WSBA, or the duplication would be inefficient or expensive for the WSBA and the Legal Regulatory Labs Board. The Legal Regulatory Lab has minimal startup costs. The Practice of Law Board anticipates, and this is a good faith anticipation, that grants can be raised to help cover the costs of nonprofit legal service providers or members of an underrepresented community who wish to partake of the opportunity to explore new rules to govern the provision of new legal services. The fourth assumption is that data-driven legal regulatory reform replaces the way all legal rules are updated and changed. This isn't the case. Rather, it complements the current and existing regulatory reform method. It adds a path to legal regulatory reform that may allow timelier changes, and by being data-driven, ensure that the unintended consequences of changing rules are exposed early, so these consequences can be managed by further targeted changes to the proposed rule. Finally, many people assume the blueprint is incomplete. The blueprint will never be perfect, and the Practice of Law Board does not know what it does not know. As the lab runs, lessons will be learned. Some ideas in the blueprint may work perfectly, other ideas will not. But monitoring and feedback will allow new information to be incorporated and changes made to the lab. How the legal regulatory lab looks when it starts is unlikely to be how the lab looks in its second, fifth, and subsequent years. The lab in Washington will have the opportunity to learn from the sandbox in Utah. This is a good thing. It shows the legal profession can adapt and change to provide the public with better legal services. The blueprint is more than good enough to ask for approval from the Supreme Court and begin work on implementing the plan. The Practice of Law Board wants to invite the Board of Governors to join with the Practice of Law Board and ask the Supreme Court to approve data-driven legal regulatory reform. DR 25 asked the Board of Governors to comment, and the Practice of Law Board will work with whatever comment the Board of Governors chooses to make. But the Practice of Law Board wants the governors to know that the Practice of Law Board would be honored to have you join with our board in taking this program to the court. Again, Chair Cherry apologizes that he could not attend today due to his medical emergency. He extends his sincere that you don't care about me. The board will be meeting at the May meeting again to address the governor's questions after the governors and executive staff have had more time to examine the blueprint more thoroughly, so the Practice of Law Board can improve it before it is sent to the court. Sincerely, Michael Cherry, Chair, Practice of Law Board. I am now open to questions. If people have questions before we get into comments or any discussions that need to happen, I will open myself up that way. Thank you.
Oh, I'm sorry, Governor Pertzer, you have a question?
I do, and Governor Couch, just curious of what, given that we're working on the structures or potential structures of the bar, how does what the Practice of Law Board, its work fall or fit within the overall bar structure and how it's going to be integrated? I believe that was what Mr. Cherry had asked earlier on, or that was a question I believe he had. I'm not sure heard any answers, and so
this legal regulatory lab would fall under the regulation and governance of the Practice of Law part of the Board of Governors of the WSBA structure. So the WSBA structure does not really affect how this plays up. If the WSBA maintains the structure, it continues as is. If the WSBA splits off, this would still be part of the mandatory bar licensure regulation portion of the bar.
great, thanks.
Clark.
I'll fix time. So a couple points and one, it's my understanding from Mike Cherry that the Practice of Law Board would be asking to create a new Supreme Court board. Is that true?
That is correct.
And then the second one is because the WSBA has to fund those boards, although I get that it's a goal that it'll fund itself. If it didn't,
Hey, Dan, we lost you there at the end. You
Certainly.
might need to refresh your audio. It's really choppy.
Okay, well, it's me, I think.
Okay.
But my point though is that because we have to fund those boards, although they would, okay, they want to be self-sufficient, financially. If they aren't, we fund that. I guess my concern about this proposal is that it seems like it's changed since the last time we saw it, in that in Utah, it's done by their AOC. It's not done by their
So I can answer why that change was made from the AOC that Utah has in place to the Washington Bar Association. And this was a long conversation about various ways of handling that. And the ultimate decision came from the fact that WSBA has the resources in place and the expertise on this. One thing that I think is really unique about the funding, and I would say, I suspect as many of you are thinking about funding this, you are thinking about the LLT program. I would caution you against that. It will be very unhelpful guidance for you as you're looking at this. And it's on page 13 of where they begin, or yeah, 13 and 14, where they talk about this. But the principle of this and the idea behind it is that generally each applicant will pay the costs of reviewing their application. So the idea is that this is a board that is funded by participation in it. There cannot be participation in it that is unfunded, because in order for someone to say, hey, I would like the practice of law or the legal regulatory lab to look at my proposal, they have to pay to do so. So that in itself, and those funds were calculated based on calculations of what the WSBA staff time would be required to review these and involved in these processes. The board is a volunteer board, but staff time and with an overhead addition onto that. So one example is that on the application fees is just a good example. It is based on an estimated cost of $200 per hour for legal professionals and $100 an hour for administrative staff, for a total cost of $600 per application. Based on this, the Practice of Law Board recommends that the cost per application will be $1,000. There is some overhead built into that, for one, because there will be inaccuracies and things, and two, as discussed, there will be people who are really serving the access to justice bent who will be unable to fully take on $1,000 fee, and the hope is that outside of grants, and not the hope, the requirement is that outside of grants, those will be funded by these additional costs that are passed on to the consumers. So unlike the LLT program, this is a program that is funded by participation in it, and there is no participation in it without funding. Does that answer your question, Governor or President-elect Clark?
Somewhat, but ultimately, wouldn't the risk of loss then be on us?
My apologies, I missed the end of that question.
I said, so ultimately, though, unlike in a Utah, if there is a loss, that'll be on us, right?
I'm sorry, you're cutting out a little bit with your speaker. It sounds a little like robotic or something. Sorry about that. I'm having trouble hearing the question.
President-elect Clark, it's not you, it's your audio is sounds like speaker interference or something. Rex is suggesting you refresh it. Refresh your connection.
While we're waiting to see if we can get President-elect Clark back at it, can we go to Governor Peterson to?
The question is up.
He's got it up.
Is if ultimately if the WSBA has a financial loss in operating the program, it would be on WSBA, whereas in Utah, because it's ran by their AOC, they bear the risk of loss financially, correct? That is correct, that if there is no one involved in this, some staff works towards setting this up a little bit, nothing happens. Ultimately, WSBA would bear that cost. It is incredibly minimal, though, and I think one thing that I really appreciate about this is that it does involve a process to check on it regularly and see what's involved with it. And without involvement, there are very low costs. So yes, we would ultimately be responsible for that. That amount would be minimal at most. Thank you.
Are we on to Governor Peterson now?
Thank you, President Solison. I guess I've kind of had this question throughout, and I don't think I've ever just received an answer that, I've gotten answers, and I recognize that Governor Couch, you may not have the answer, but I'll ask it, and if you don't have the answer, that's fine with me. My understanding is it's not really something that affects the members in any real way, because essentially these people are all people that are already practicing in the state. They're just doing it in an unauthorized fashion. And then, this would essentially be some sort of registration, so that they go from unauthorized to, and I think that's another reason why it's not an access to justice either, right? Because it's not an increase. It's just, we're taking these people that are currently unauthorized, we're making them quote unquote authorized. My concern is, are they going to make it so that, because some of these online providers, some of the things they do really well, some of the things they do, it's borderline malpractice. Some of the things they do, frankly, it is malpractice. And is what Mr. Cherry is what is he proposing going to make them stop committing malpractice in the state? I mean, that's my main concern, because we're giving them the badge of WSBA. So then the public's going to be like, whoa, Rocket Zoom must be really good now because WSBA registered them. And so where the status quo is, it's kind of like consumer beware, and they're on notice because we haven't given them the WSBA badge of approval. And so, part of our mission, it's members, public, and champion justice, right? So this is one of the big ones. And if we're essentially deceiving the public because we're making them think that they're now providing great legal services because they're registered by WSBA, that's actually putting the consumer and the public in a worse position, I would argue, than they're here in unauthorized practice of law.
Trying to find a page. There's a great page on this, but I can't find it at the moment. So you'll have to trust me and dig later. So there are two ways I want to address this. One is what we are seeing is not that there are people out here who have been doing these unauthorized things, getting licensed now. What we're seeing, and I think where this affects the members actually, is that we're seeing lawyers who are facing struggles over decades of declining revenues because of structural inefficiencies, seeing ways to say, how can I serve these people who are calling me who can't help? In my practice area, anyone else does injury law, about 70% of the people who call my office saying I want help end up getting nothing out of that. And it's a business model. So most of who is benefiting from this so far in the Utah model and other states has been actually practicing attorneys saying, I wonder if I can do something different to find a better way of life. So in that way, it affects the members. As far as the unauthorized people, we haven't seen a lot of that happening yet. I'm not saying it's impossible, but I will say that, assuming there are people who were unauthorized in providing service and now we're giving them a stamp of approval, I think this does change the game for those people in really substantial ways. Number one is, and this is the page I was looking for, Governor Cherry has a great part in this proposal where he says there are certain rules that we can never waive. We cannot waive competence. We cannot waive confidentiality as we talk to people. But there are things like non-lawyer ownership that might benefit a company. And I think the most remarkable thing about this is that in order to comply with this and get into this practice of law board, if there are these unauthorized organizations out there coming to us, they have to prove that they have a viable business model. They have to assess and do a risk assessment on how they're going to cause harm to people, how likely it is, when it's going to happen, and what the benefits and risks are associated with that. And there are multiple tables they have to go through in providing this information to determine what's going to go wrong, what's the harm that's going to happen. And then the most remarkable thing about this is they have to file quarterly reports on what's going on with them. So in a way, you're taking, if there are unauthorized people who are doing these things now, you're bringing them in, you're saying, great, you want our stamp of approval? You have to go through more regulation and assessment than any lawyer ever has to do. Like I was actually joking with Lauren earlier today, like I would love to see what would happen if every law firm, when they started out as a new firm, had to say, okay, for 2 years, we're going to report every quarter to the WSBA, how we're helping our clients, what we're doing on these cases, where our like these reports is really remarkable. So I think, what we're not going to give them. What we're going to do is find out who's really good at this and who's not. And hopefully, as people are going to those unauthorized legal service providers, they'd stay instead. You know what? I'm not going to go to that. I'm going to go to, I can't afford a lawyer, but I'm going to go to the person who is submitting reports quarterly, because I know if they harm me, it's going to be reported quickly and they will lose their license and there'll be some recompense for me. Thank you.
You have Nancy Hawkins and then Chief Disciplinary Counsel Doug Endy.
Thank you. Could you give me an example? Because I remember Mr. Cherry giving us some examples at somewhere, some other place, some other meeting. An example of that you just mentioned, for example, an injured person who came to you, you couldn't help, but here's some other model that could. And then more directly for my section, an example of a family law matter that would be better addressed by one of these companies or models rather than the existing lawyer model.
Okay, so I can give you an example in the injury world quite easily. I don't know how many of you have heard of PatBot, this amazing robot that exists for free right now. That's why it's run by our website, but it could run separately. And this is a robot we have on our website that helps people draft documents around workers' compensation. Now it is our firms, we run it, we create all the documents, we do all the work, but the idea there is that we could automate these things and help more people who couldn't necessarily come to a lawyer or didn't want to spend the money on a lawyer. Family law, I have a couple thoughts for you on this, but I first want to say, you asked me what would be better than, and there are two sides of that. If you're asking me how a company like this could serve people better than a lawyer, well, better than a good lawyer, I don't think there is necessarily a way that these companies could do that, but it's 84% of family law cases have at least one party who is pro se. So those 84%, there are many ways. One really good example, if you want to look at this, is Aaron Levine's Hello Divorce. Michael Cherry mentioned another one in here that I can't remember the name of right now that deals with family law and the blueprint, and I'm happy to provide this to you, Nancy, or to your section. Hello Divorce has set up a system in place to create multi-tiered options for clients dealing with family law. And tier one begins with, she has forms and videos and guides you through the process, and you get to represent yourself with a crash course on how to represent yourself in family law court. Option two is you have a paralegal who helps you with these things and drafts along the way and gives you some guidance on this. I think there's an option 3 and 4, with the ultimate option being you have an attorney who does everything for you. And that attorney still benefits from these systems that do the document drafting for that as well, to be more efficient and offer services at a lower rate than a lot of other family law attorneys in that area. That is a company that existed beforehand in Georgia. And then she is already participating in the Utah sandbox, if I'm remembering correctly, and has been successful so far in that. So that's a good example of a solo practitioner finding a way to build a better life and have some more free time and go on vacations. If you follow her Instagram, it's pretty fun.
Nancy Hawkins, do you have any follow-up questions?
No, but I'll take advantage of Jordan's offer to give me some more information, and we'll get back to you after we look it over.
Fantastic. Thank you. I think we have Chief Disciplinary Counsel Andy, followed by Chief Advance Director Kevin Platchey.
Thank you, Mr. President. The blueprint acknowledges that it borrows conceptually very heavily from the Utah sandbox. Now, as I understand the Utah sandbox, and I think President-elect Clark alluded to this, the Utah sandbox is implemented through the Office of Legal Services Innovation, which is an office of the Utah Supreme Court. As far as I can tell, and I may be wrong, so correct me if I'm wrong, the Office of Legal Services Innovation does not use resources of the Utah State Bar. If I'm wrong, and if it does, I'd like to know how that works. But if I'm right, and they're not using resources of the Utah State Bar, why in Utah was there sufficient expertise and wherewithal to launch this initiative, where in Washington, we need to lean on and utilize the resources of the Washington State Bar Association?
So I think part of that comes to, and I can never remember the full name of it, but the organization you mentioned that the Supreme Court created that is running this does not exist in Washington. And so I think there's a reality to which we are in a different place. I think historically, one of Utah's Supreme Court justices, whose name I'm forgetting right now, was very supportive of this, and that helped drive a lot of this. And that was one big change. I think also there's an element to which we were able to look at what is happening in Utah and see, can we do it better? And I think that's where the Practice of Law Board came down on the idea that we could work with the Washington State Bar Association rather than recreating a wheel when we have a wheel that works very efficiently, very effectively. Can we throw the load of our stuff into the back of this truck that already has 18 wheels on it rather than building a new truck to carry this thing? And I think that is part of why we were able to say that we can keep costs down and keep costs incredibly minimal on this, because we have a program that is funded by participation. And because when that participation comes in, we are able to scale up and adopt and use resources of the Washington State Bar that exist for this. Whereas if we had to scale it up to begin and say, well, we need to hire people who can review these, we need to hire staff and legal people that have the mindset and knowledge around this, that is going to take a big startup cost. And there were conversations about grants looking at doing that, about pushing the Supreme Court around that. And what we ultimately decided was we think we could do it better by, unlike the LLT program, which I actually am a fan of, but unlike the LLT program, if I can put a whole bunch of startup costs into this, we can say that this begins, we can put the board together, and then nothing happens until someone submits an application. And when someone submits an application, we get a check in our hands that says, hey, here's how we're going to pay the state bar to do the services and resources that we have involved in this. And that's the hope behind this.
Chief Advancement Director Platchy, you're up.
Thank you, President Tollefson. Jordan, a question I have is, it's my understanding that we may not have performed an actual full-on fiscal analysis of establishing some of the cost with our finance department. Do you know for sure if that's happened or not? And if it's not, I just want to put out there that it would probably be a good idea to have our finance folks work with the committee to actually determine, and probably with staff liaisons to determine sort of what the staffing would look like into it and how it would be allocated, so we could get to some very specific costs that would be associated with it to help determine application fees and that kind of thing. But do you know for sure if that's been done? It's my understanding that it may not have been done with finance.
I don't believe that has been done. And I think that in part is because it has been under the Practice of Law Board now. In fact, I think one thing that would be great that comes out of this, and I'm not sure if we'd need a motion or anything like that, but would be to say, hey, between now and May, we'd love to have that fiscal analysis done, because now that we are working with the Board of Governors, I think I personally would love to see that happen. So.
Any other questions for Governor Couch, who's standing in for Chair Michael Cherry? Okay, we've got two. We've got Chief Disciplinary Counsel Hendy again, and then followed by Governor Higginson.
So I think this is in the nature of a follow-up question to the colloquy we just had. So the vision is nothing happens. WSBA staff is doing nothing in preparation for this until $1,000 check comes in. And at that point, we pull ourselves together and figure out what we're supposed to be doing. And that money is conveyed to the bar to offset the time spent by WSBA staff to actually do the work of the lab. Is that correct?
I was perhaps a bit overly hyperbolic. That is, conceptually, I think obviously there would have to be, and this is, I think, where an actual fiscal analysis would be helpful to understand what is involved in this process. But I think the conceptual idea is that the reality is there will be other things on there, which is part of why, if you look at the pricing models, there is excess in every aspect of the pricing model around licensing fees, around that sort of thing, because we know that there will be other things that are ancillary to this that end up taking time as part of this process. And I will say, I'm going to get out of Governor Cherry's role for a moment and say, personally, if we wanted to tell the Supreme Court that we think they should set up their own system to fund this, I am so in favor of that. I love that idea. I, in fact, pitched that when we were talking about this, the practice of law board. That's where I wanted it to be done. I think it's harder to do. I think the Supreme Court will like this, but I love the idea of this organization being self-funded, running on its own. The only thing that some of you might not like is that out of that, the Board of Governors and the WSBA would probably lose some of its regulatory control over these things. But personally, I love that idea of letting this thing be independent. And there are some who are in that space that also say, like, I don't want to deal with the Board of Governors. Why aren't we independent? We should have the Supreme Court set up our own independent thing. So it's funny, you get that on both sides. But I think a better, more useful system is this going forward.
And just a quick follow-up, and really I'm asking these questions so they can be conveyed to Mr. Cherry and the practice of law board. And he'll presumably watch this this meeting. Does the practice of law board believe, or has any analysis suggested, that the revenue taken in by the lab would be sufficient to fund new staff at the Washington State Bar Association? Because otherwise, existing staff will be doing the work of the lab. And I can tell you that it's not a matter of dollars, a couple of $100 here and there. Existing staff at the Washington State Bar Association are fully occupied in the tasks that they have already been assigned to perform.
Again, I will say, I think this is a good reason to have a fiscal analysis. Personally, I'd also say we need to hire more people at the WSBA to build a little slack into these things. I'm doing this in my office right now too. You got to invest in your people, invest in having slack so these things, but that's me personally. But no, I think this is where more specific fiscal analysis that really addresses how this goes and what the impact is going to be on particular staff that can get that specific would be a really helpful next step. Now that we are here at the Board of Governors, I would love to have the Board of Governors support in doing a fiscal analysis. So thank you.
Thank you.
Governor Higginson, you're up. Go.
Sorry, Doug covered what I was going to ask, so I don't have anything else to ask at this point. Thank you.
Thank you. Any other comments or thoughts regarding the report from the Practice of Law Board that they were required by GR 25 to give to us? And I think they'll be back at the May meeting, correct?
Yes.
So they can meet their deadline of July 1st for the Supreme Court.
We'll be back in May. And I will also add that, looking at what's happening in other states right now, it is a slow increase in people participating in this. So, the first year there probably wouldn't be a new staff member at WSBA, it'd be a few hours of time. But hopefully the buildup is there, is my guess. And that's what we're seeing so far as this takes off and people find better ways to help. So.
And I'm confident that our executive director can do the fiscal analysis before that. Okay. Thank you so very much. We haven't taken a break. I mean, we've been on this since 1 o'clock. We haven't taken a break. So if it's okay with everybody, I think we should take a 10-minute break. Then I would like to do one more jump in the agenda to the Character and Fitness Board report. And then we can go back to the discussion that about the Personnel Committee ED evaluation. I checked in with the people that were going to present on the creation of committee to explore and advise the BOG, and they're good with kicking it over to the May meeting. So we won't be hearing from them today. Okay, so 10-minute break. See you back in 10 minutes.